training. If you have questions, put them in the chat or raise your hand. Either is fine with me. I think for this particular training, it makes sense to ask the questions as they arise, as opposed to some trainings where it may be better to answer them at the end, just because there are so many components of Section 504 that by the time we may get to your question, if we've moved to another section, it may make more sense to answer it in the moment. So don't be shy about asking questions if you do have anything. Today is more of a high-level overview. So if there are specific questions, we may defer to answer some of those offline, but please, this is a safe space. Go ahead and lob those questions at us. All right. So we're going to start with just in general, Section 504. If you are brand new to kind of this term or to the affordable housing world, Section 504 generally means that no otherwise qualified individual with a disability in the United States shall, just because of the reason of disability, be excluded from participating in or be denied the services of or subjected to discrimination under any program, service, or activity that's receiving federal financial assistance or under any program or activity conducted by an executive agency, which, as you guessed it, includes HUD. So regulations governing Section 504 are located at 24 CFR Part 8, which is the non-discrimination based on handicap in federally assisted programs and activity of the Department of Housing and Urban Development, or HUD. So Section 504 applicability, it applies to program accessibility for all applicants for and recipients of HUD assistance in the operations of programs of activities receiving this assistance. So there's a pretty substantial laundry list of programs that are governed by this. So the elements of, we'll go through some of the federal programs that you might encounter if you're applying for assistance or gap financing from DOH. So that would be anybody that's receiving CDBG, so anybody that's receiving Home Investment Partnerships or Home and Housing Trust Fund, or HTF, Emergency Solutions Grants, or ESG, HOPWA, which is Housing Opportunities for Persons with AIDS, public housing, housing choice vouchers, or Section 8, supportive housing like Section 811 or Section 202 or 202 PRAC, and homeless assistance programs. So thinking continuum of care or other McKinney-Vento programs like those Shelter Plus Care or SRO Mod, if you're familiar with those some older programs, and recipients of NOFA funding. Grants or loans made with state funds follow these rules as best practice. All right. So some elements of Section 504 would be non-discrimination, program accessibility. So a housing program, when kind of viewed in its entirety, needs to be accessible and usable by persons with disabilities. So that's effective communication with applicants, beneficiaries, the general public, making reasonable accommodations, wheelchair access, and reasonable accommodations, which would be changes to rules, policies, or practices. This is also required by the Fair Housing Act as well. So there's sometimes multiple federal regulations that are overlapping and requiring some of these things. And effective communication. So is the information being shared in a manner that can be understood by all residents? And of course, physical accessibility. So that would be any barriers in rental housing, what steps the agency must make, to the greatest extent feasible to ensure accessibility by residents, applicants, et cetera. We'll go over all 5 of these elements kind of in a little bit more detail in the following slides. All right. So firstly, for non-discrimination, this would prohibit discrimination on the basis of disability in any program or activity. And you may not impose stricter standards on a person with disabilities, so implying stricter screening criteria or charging a higher security deposit If somebody's coming in with a wheelchair and you don't traditionally check landlord, history, you can't then check landlord history to see if they were a good tenant at a prior property. Treating everybody the same, regardless of whether or not they're coming in with a disability, whether it's a known or unknown disability. And you cannot charge a higher security deposit. So if somebody comes in and they've requested a reasonable accommodation, so there's some disability and you're concerned that they may cause additional damages to the unit, cannot charge them an additional security deposit for any reason. And lastly on this slide would be programs and services to be conducted in the most integrated setting appropriate and to the needs of the person with the disability. So not segregating somebody because they have a disability and you may not have, separate meetings for persons with disability, things like that, making sure that everybody's integrated together. Nextly, we'll go to program accessibility. So in a housing program, when viewed in its entirety, it needs to be accessible and usable by persons with disabilities. So making sure that you have effective communication with applicants, beneficiaries of and members of the public, making reasonable accommodations and things like that. If you're having, an open house to accept applications, making sure that event can be accessed by the general public, which may contain persons that have disabilities, making sure you're holding home buyer webinar, home buyer events, or things like that in an area where everybody would be able to come and gain the same information, regardless of whether or not they may have a disability. All right, we'll take a little more time to go over some of the things with reasonable accommodations and reasonable modifications, because this is something that we get a lot of questions on and is something that the state monitors for during the contract period and during the period of affordability for those of you with HTF or home funds. And so a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy a dwelling unit. This is a much larger element of Section 504 and fair housing. DOH's Office of Rental Assistance did a more in-depth dive on reasonable accommodations, and it's linked here, and you'll get a copy of these slides after today's training. The reasonable accommodation, think of it more as somebody just needs either an administrative change or a change to a rule that's in writing or an exception to a policy as opposed to a change to the unit. So this would be, if a person has a cognitive disability and they need somebody to help them review documents to ensure that they fully understand them, or if somebody has a visual disability and they have a friend or a family member help them read things to ensure that they know what they're signing. Those sort of kind of more adjustments would fall under reasonable accommodation. And so there's a HUD handbook called the Procedures for Providing Reasonable Accommodations, and that can be a helpful resource if your organization needs a refresher on reasonable accommodations. I also strongly suggest doing a little spring cleaning to go through and take a look at your reasonable accommodation policies and procedures, and just make sure that policy spells out the responsibilities of each staff member involved. So who is the point person for collecting reasonable accommodations? Do all staff members, both maintenance and office staff, know what to do if somebody mentions to them that they need a reasonable accommodation? And folks don't need to use that exact term. So oftentimes I would have a maintenance person, working in a unit, and the tenant would be home, and they may interact with the maintenance person more often than the office staff. So super important to ensure that all staff are trained on this. And the tenant may report to the handyman or the painter, that they are having trouble loading the washing machine because because they've had now limited mobility or things like that. And if that staff person is trained to understand that this person might benefit from a reasonable accommodation, that can be really beneficial for the organization. So the policy should spell out, who all has been trained in this, responsibilities of each staff member involved. Your reasonable accommodation policy should also specifically outline the time frame that staff has to review these requests, the time frame that they will reach out for verification and respond to the tenant. Additionally, your RA policy should include confidentiality measures as well as limits to the information requested and stored. So, for example, you should not be requesting any details on the nature of the disability or ever a diagnosis. And there should also be a clarification in your policy on if that information is voluntarily shared, that it will be refused. So there's no reason for a property management company to have somebody's disability details or their diagnosis or the prescriptions that they're taking, unless those things are needed for, another reason, but you should not be collecting or storing that information for any sort of reasonable accommodation request. The policy should also include information about how your reasonable accommodations are tracked. So it's best practice to keep a reasonable accommodation log. And if you're here from a larger property management company, generally you'll have one central 504 coordinator who will be, kind of the ultimate point person for reviewing and approving or reviewing and denying those. And that person would maintain a reasonable accommodation log. And that log can be really helpful to know kind of over time, are we treating all of these applicants or tenants across our whole portfolio the same? The policy should also include a process for appeals. And a friendly reminder that something that is on the reasonable accommodation policy should be that these requests can be made orally or in writing. So you may not require that somebody put their request in writing. So somebody can come in and dictate to you what they need, and your staff can assist them, in putting that down so that you have it for your records and can, respond to that. The state will review this policy at monitorings or at closeout if you are not subject to long-term monitoring. And a hot topic in housing is always service animals and emotional support animals. Those would fall under reasonable accommodations at no pets properties. I think we could do a whole hour-long training on service animals and emotional support animals. But if you have specific questions, drop those in the chat, or we can talk offline if it's a larger question. All right. So next is reasonable modifications. So these often fall under accommodations, but they're technically a little bit different, though organizations generally use the same forms for requests, verifications, and approvals, and kind of the same workflow for reviewing them. But a reasonable modification is a structural change made to the premises. So a person with a disability may need either a reasonable accommodation, so something changing the policy, or a reasonable modification, or both, in order to have an equal opportunity to use and enjoy a dwelling, including public and common use space. So an example of this would be if somebody's coming in and they need a reasonable accommodation, so they need to have a live-in aid in a unit. So that would be an accommodation that they're, moving in an additional person to operate as a live-in aid. And they may also need grab bars installed, and that would be a reasonable modification. So that's an example of somebody that would kind of need a two-prong approach in order to be able to fully enjoy the dwelling. And not all persons with a disability will have the need to request a reasonable accommodations, but somebody with a disability does have the right to request or be provided a reasonable accommodation at any time during the application process and their tenancy. So if somebody moves in and they says, I don't need grab bars, they may request that at a later date. And some of you on the call may have newer properties in your portfolio where you have units that are, ADA accessible or UFAS or, designated as mobility impaired accessible. And you may put somebody into that unit and they may still need a reasonable accommodation because everybody's disability is a little bit different. And so even if they're in a unit that's already designated as such, they still have the right to request additional modifications to it. Other common examples that we see for modifications beyond grab bars would be ramps, persons needing a front-loading washer or dryer, installing automatic shut-off faucets for persons with cognitive disabilities, or visual alarms for persons with hearing impairments. Those are kind of some of the common ones that we see when we're looking at reasonable accommodation logs. And of course, the question is, who pays for all of this? So if you are generally under the Fair Housing Act, the housing provider is responsible for the costs associated with reasonable accommodations, while the tenant is responsible for costs associated for modifications. However, housing providers that receive federal financial assistance are also subject to these requirements, including the cost of any modifications, unless it poses an undue financial and administrative burden. So if you're receiving federal funds, then you would be responsible for the cost of these modifications. And so the housing provider would need to do that unless it posed an undue financial burden. And so that burden would need to be actual and not speculative. So would be reviewing, the escrow statement and ensuring that you truly don't have enough in reserves to make that modification. Things that we've seen for that would be a tenant that's requesting an elevator in a non-elevator building. The building couldn't support an elevator physically, and also the cost of it was, beyond what the property could afford. So that was something that was an undue financial burden, and that request is denied. But they were able to provide an alternative, which was transferring the tenant to an accessible ground floor unit in that building, so that even though they weren't able to approve the initial request, they were able to work with the tenant to get them to a place where they could enjoy the unit fully. So you'd be, if you're going to be denying a request for that reason, you'd be looking at the financials and considering the scope of the program. We've also seen some that have been denied if somebody's asked for a door to be widened to allow the wheelchair to get in, but after a structural review, widening the door was not possible for that particular unit. So again, a transfer was the alternative option. And we want to remind folks that you cannot consider future requests as a defense. So each request should be evaluated independently. And this is where it can be really helpful to have your 504 coordinator be someone who is not directly at the property. And I say that because sometimes these can become emotional, especially if it's a tenant that is has had issues or may not be the easiest to work with. To take some of the emotions out of the evaluation of the request can be really helpful and help protect the company to ensure that there's no fair housing violation, or that there's not any accusation of the person being too involved with the tenant to be able to make an objective decision on it. And so that's why we suggest that a 504 coordinator is somebody who's stepped a little bit back beyond the day-to-day interactions, if at all possible. And with regards to thinking about the request that's in front of you, if you have this is a common example is with emotional support animals. Considering that one individual request, without thinking about the fact that if somebody gets a cat as an emotional support animal, then everybody's going to want a cat. You can't think about those future requests as a defense, is how it's worded in the language. You need to just review the one that's in front of you at that time. That can be complicated, but that's the best way to do it. Also can be helpful to look back at your reasonable accommodation log and see how the organization has handled similar requests in the past. Right. And the next element is effective communication. So if a housing provider must furnish appropriate auxiliary aids and services where necessary, such as use of interpreters, transcription or captioning services, accessible electronic materials, websites, large print, braille, etc. So there's no one-size-fits-all approach for persons with disabilities. So an example of this would be today's webinar. So when Yvette kicked us off, she mentioned that at the bottom of our Google meeting, there's a closed captions option. So if you are, we're still in the time of COVID. So if you're having your tenant meeting, maybe you're to the point now that you're having some people in person and also, online. You can have folks watch it online with closed captioning. So that would be something you could offer your tenants with hearing impairment so that they can fully understand, fully access the information that's being shared during your tenant meetings. And they can also, type in their questions. So things like that may be helpful if you're having, meetings and you have any tenants or persons in the public that want to get information about your organization. The next element is accessibility. So this applies for federally funded new construction of projects with 5 or more dwellings or substantial alterations of projects with 15 or more units. And so for these, it would be a minimum of 5% of the units must be designated for persons with mobility disabilities, and an additional 2% units for persons with hearing or visual disabilities. I should also say that it's a minimum of 1. So if you have a 15 unit building, 2% of that is going to be less than 1 unit, but you need to round up. These need to be on an accessible route, or physical requirements apply, and other physical requirements apply to common spaces. And I will say that in a lot of new constructions, we're seeing that the accessible units are mobility, vision, and hearing impaired, all in 1 unit. And that's fine, but just ensure that if you have, a 100-unit building, that would require that you have 5 units, a minimum of 5 units designated for persons with mobility impairments and 2 units for those with vision, hearing. So if your units are combination of all of those, you need to get 7 total, not just 5. So even though those 5 would be for anybody with an, hearing, vision, or mobility impairment, you need to still meet that minimum, as if they were stacked separately. And I hope I'm explaining that well. If I should go over it again in with different language, please drop a note in the chat. As an aside, the Fair Housing Act applies to buildings with 4 or more units, regardless of the funding source. And so that also requires that ground floor units meet some additional design elements. If you have specific questions on, the design accessibility, feel free to reach out to us, and we can walk through that more one-on-one. Right. So the next we'll talk about accessibility for rehab. And so the prior slide was for new construction. For rehab, for accessibility, there are some kind of different thresholds, because you may not be rehabbing a building to a point where you can meet the threshold that we spoke about on the prior slide. But if you're doing substantial alterations for a a project that has 15 or more units and the cost of the alterations is 75% or more of the replacement cost of the completed facility, that the new construction provisions that we reviewed on the prior slide do apply. So that would be the 5% and 2% for mobility and vision hearing. And if you're doing a unit alterations or the project involves fewer than 15 units, or the cost of alterations is less than that 75% replacement cost, but you're overhauling kitchen cabinets, bathroom, tub, shower, toilet, and entrance door jambs, then the more stringent, the 5% and 2% do apply. And if the rehab doesn't qualify as either of those, you're just doing kind of a more minor rehab and doesn't qualify as substantial under either of those, then alterations should be made to the maximum extent feasible until that benchmark is met. And for accessibility, this is something also that we see a lot of questions on when we're doing monitorings. The accessible units that are in your properties should be rented to persons that are going to be, seeking an accessible unit. And so the HUD Section 504 regulations require that the recipients, so that's owners, agents, management companies, adopt suitable means to assure that the information on accessible units reach otherwise qualified individuals with disabilities who need the features of those units. So thinking of your marketing efforts. So in your affirmative fair housing marketing plan, if you're required to have one of those, or if you opt to have one, you will have identified persons that are least likely to apply. And if you've identified disabled persons as somebody who's underrepresented in either your marketing area or your census tract or on your wait list or in your property, you need to be doing additional outreach efforts to ensure that the information about these accessible units is getting out into the community. So, finding publications that work specifically with persons with disabilities, working with organizations or community contacts in the area that are working with persons with disabilities, so that they know that applications for affordable apartments are available, how to apply, that you're providing, as we spoke about earlier, accessibility to the office if they're coming in to drop off an application, or if they have questions, that they can use the TTY to do the phone relay, things like that. So you're making sure that you're getting your program out there in the community, so that these accessible units that you went through all the work to construct and make are being used by persons that are out there trying to find accessible apartments. These available units need to be offered first to existing tenants in need of an accessible unit. So if you have, a reasonable accommodation from a tenant that may have had a stroke and is now in a wheelchair and they need an accessible unit, and one comes available, they get first, the first option to take that as an internal transfer for their reasonable accommodation. So then after that would be persons on the wait list with a disability. And then lastly, if you don't have anybody on your wait list with a disability and you don't have any tenants that need that accessible unit, then you would offer the unit to the general wait list in chronological order. A lot of folks have, a rider in their lease that if somebody's taking an accessible unit that doesn't need those modifications, that they may need to be transferred out if somebody does need that unit. We often see that as sometimes it's called a barrier-free unit rider, things like that, so that it can be freed up when the need arises. And of course, with accessibility, you want to make sure that you outline this process in your tenant selection plan, and that all staff is familiar with the way that these requests are processed. So whenever, that vacant unit comes available, if it's accessible, just making sure that everybody involved with that turnover process and the re-rental process knows that it's an accessible unit, and checking to make sure that are there any RAs waiting and for internal transfers, and then if not, going to the wait list. Any questions so far, Yvette?
Nothing has come through yet.
Okay. Additionally, with accessibility and offering these units to persons with disabilities, it is important to mention that an owner may not skip over a family that has reached the top of the wait list and has indicated a need for a certain unit accommodation because of a disability. So if separate waiting lists are used for persons with disabilities, they must also be placed on the general waiting list and given the option of the next available unit if they come to the top of that list. That family must be given the opportunity to benefit from the program and decide for itself in compliance with Section 504 whether that available unit that may not be designated as mobility, vision, or hearing impaired meets the needs of the family based on the size, location, or facilities. So that means that the owner must notify the household whenever any unit becomes available without regard to the unit accessibility. That applicant, if they happen to be the top of the wait list, may accept a standard unit, particularly when units meeting the household needs are in short supply, and they may accept the unit and they may request a modification or an accommodation. So I hope that's clear, but it's essentially making sure that you're not accidentally, disadvantaging a household that's identified as needing an accessible unit, even if one is not available.
We did have one question come in, Olson.
Mm-hmm.
It says, would it ever be required that tenants switch units before turnover? For example, if somebody has an incident that causes them to need an accessible unit and one is occupied by a tenant that does not need it, could they swap?
So that would depend on what's written in your lease. So I've seen a lot of organizations have a barrier-free rider where if they had an accessible unit come available, and at the time that it became available, nobody that was in the building at that time needed it, and nobody on the wait list needed it, and it was re-rented to, I'll just say, a general public person on the wait list, somebody that didn't have an identified disability. Some management companies will, make sure that they understand that they are moving it to a unit that has, is a UFAS unit and has been designed for a person with disabilities, and that they understand with reasonable notice and compensation and assistance would be moved internally if somebody did need it. Now, I don't know how often that, has actually been used. When I was working in, the property management world, we had that rider, and I don't think we ever compelled somebody to move because we had enough, accessible units that we were able to kind of make it work. But I would discuss that, with your legal team, and also, reading what's in your existing leasing paperwork.
And somebody just added a comment that said, we have an addendum like that, we can require transfer if there is an application who requires the features, but we don't require vacating the property, and they haven't ever used it.
Yep. So I would say that you wouldn't ask the household that is residing in the accessible unit to move out. I would, the barrier-free rider would say, that they would be transferring to, to a comparable unit. So size, amenities, but not to vacate the premises. And to the person that chimed in with that, haven't ever used it yet, say it's pretty uncommon that you would make that, because it is a lot, to ask a household to move, especially if they've been there for a long time and maybe maybe you inherited a property that, that wasn't very well explained, that can be really complicated as well. So that should be definitely a conversation with your in-house compliance and legal team of, what do we have signed by our tenants, what's been communicated to them, and what is the need of the other tenant that may need the transfer, may need those accessible things. Can the modifications just be done to their existing unit? Or can they be done to the existing unit now and then, put onto the top of the wait list to transfer into an accessible unit when one becomes available? So there can be some kind of creative solutions in there in working with the household in need. All right. So the question that just came in, what would you consider if someone was requesting zero contact and zero entry into their apartment due to a mental illness? Further added, if the person is verbally abusive when you do make entry after a demand letter. So zero contact, meaning that they don't want any face-to-face, is what I'm going to assume that means, and zero entry to the apartment due to a mental illness. So I would, that's a modification, that's kind of a health and safety. So, if they don't want entry to the apartment, I would be a little bit concerned because you don't know if there's an existing exigent health and safety, and you don't know if there's the state may have an interest in. And so I'd be interested to hear, what the third-party verification comes back to say. So, the process with reasonable accommodations and modifications is the tenant makes a request, and with that request is a consent for you to verify with their, to verify the need. And then lastly is to make the decision on it. So after they've made the request, of course, you'll take the request. You'll never deny the request without, seeing it. And you'll accept the request either in writing or verbally, and then you'll get the consent to do your third party, and would be interested to see, what the third party came back saying, whether or not that was reasonable. But you do need to have access to the unit. I think it would be possible to do zero contact. So if somebody doesn't want to have, is having severe anxiety and can't be around folks, you could coordinate with them to do the unit inspections without them home, or some creative solution around that. And with regards to the verbal abuse, that's not something that is a reasonable accommodation. That's something that I would say to work with, the tenant. If you're in a supportive housing situation, working with the supportive housing provider to address that. All right, and just make sure that I covered everything here. Were there any questions on kind of the order in which you're offering accessible units to persons on the wait list versus internally versus general wait list? I don't see any. All right, and so the next is completing the Section 504 self-evaluation. So this is something that was created many years ago when we started taking stock of, some of these unintentional barriers for 504. And there's some on DOH's website or by request, and we link to that area at the end of the training here. And it gives organizations an opportunity to evaluate policies and procedures. And that can be a really helpful tool. It's required when you're working with one of our devos on a new project, but it can also be really helpful to do, every couple of years during this, I love to call it the spring cleaning period, where you can go through all of your kind of large documents, your management plans, your tenant selection plans, your marketing plans, and Section 504 self-evaluation to really see kind of what your blind spots might be. And especially if you've had staff turnover, and it's a good way to regularly inform and train staff on those non-discriminatory practices. So like we talked about earlier, it's often that we see front of house, or leasing office staff trained in fair housing, 504, reasonable accommodations, but we don't always see, the handy person and the painter and the porter all be trained on those as well. But really, those are the folks that have a lot of contact with our tenants, or somebody, they may be outside shoveling snow or mowing the lawn, and somebody may walk by, and stop that person and ask those questions. So it's really important that everybody is trained in all of those practices. So your Section 504 self-evaluation can help kind of bring to light some of those kind of blind spots. And this self-evaluation can also help evaluate ongoing accessibility to all programs and activities. And it is specific to each property. So if you've got multiple properties in your portfolio, it can be really helpful to do one for each. And I just got a message that I'm kind of cutting out, so I'm just going to turn off my camera and see if that helps a little bit. And after the self-evaluation, it also goes over notifications of rights and beneficiaries to employees, discusses policies that may limit handicapped participation, information and training for staff, your ability to ensure no discrimination, program accessibility, and an emergency evaluation. So strongly suggest that if you have a few minutes to work through that with your spring cleaning. And these forms can all be found on DOH's website. Again, we'll send out a copy of these slides so that you can, so that you're able to use those. We have the self-evaluation. We have samples of the request for reasonable accommodation, as well as the verification for need, and verification of continued need for reasonable accommodation. And so those are templates. You're welcome to take them and make them your own. You may have existing ones. There's also some templates that you can find online. Just make sure you're using a knowledgeable source. And some additional resources on 4 of the 5 elements that we discussed today: non-discrimination, your RAs, effective communication, and physical accessibility. There's a lot of trainings on each of these you could spend hours learning on, but I hope that this broad overview at least gave you a bit of a teaser for some of these larger areas of compliance under 504. And any final questions that may have come in on any of those elements or resources?
I don't see any questions in the chat. Feel free to ask any additional questions or unmute your line if you'd like to ask those questions out loud. Does DOLA have a self-evaluation form?
We do. And that's on the Section 504 self-evaluation is on our website. And we can also, when we send out the slides, we can attach that as well. It indicates that it's for one specific federal funded program. Oh, Teresa just dropped it in there as well. But it can apply for all programs, whether or not it's federally funded or state funded. Thanks, Teresa, for sharing that link.
Great. Any other questions?
All right. Thank you so much for attending. I will say we are more than happy at this date to answer questions specifically if you have a question about your organization's um, reasonable accommodation policy and procedure or the tenant selection plan, or you just want a second set of eyes on it to make sure that it complies with all of those regulations that may be applicable at your property. And you can find the list of asset managers for your particular funding source on our website as well. And feel free to reach out to one of us. And if you didn't land in the right person's inbox, we'll get you pointed in the right direction. We'd rather help you solve the problem, in the moment than be answering the questions the day of a monitoring. So don't be shy about reaching out. We're more than happy to assist.
Great. Thank you so much, Allison, for your excellent presentation. A recording of the webinar will be posted on the website under the training section in the next few days. We will also be sending out slides, copy of the slides to anybody that would like those, or just anybody that registered for the webinar. And as always, check out our training page. We have a lot of upcoming webinars. If at all you feel like there's something we haven't covered that you would like us to cover, please feel free to reach out and let us know as well. And with that, I think we will let you all go. Thank you so much for attending.